Yes, Mr. Singh.
Yes, Lady and Lords. So just before the short adjournment, my Lord Hodge asked me for some further submissions on whether the bra performed a particular service relative to the main function of the breast form. Now, when Lord Justice McComb considered this issue in his judgment below, which it may be worth just turning up, it's MS 123. At paragraph 97, he said, after considering Turbon 1, that for my part, I would have thought that a printer cartridge was classically something which performs a particular service relative to the main function of the printer, namely to enable it to print, but apparently not. He also considered the bra and the breast form at paragraph 86.
Yes, I mean, that statement depends on a rather broader view of what the relevant function of the printer is than the CJEU seems to have taken.
Yes, and possibly a broader view of what accessory means. Because when we look at paragraph 86, what Lord Justice McComb says is about 3 lines down in paragraph 86. In general, accessories to parts included in chapter 90 are to be included in the chapter. In any normal parlance, the MB, the mastectomy bra, would surely be an accessory to the breast form. It holds it up. And then in the final sentence of that paragraph, he says, the mastectomy bra is therefore, in my view, as a matter of simple common sense, an accessory designed to perform that imperative function in relation to the breast form. But notwithstanding Lord Justice McComb saying that, he was persuaded, after considering the Court of Justice authorities, that the bra was not an accessory. And there are just 3 paragraphs in those decisions that I'd like you to look at. So if we go to Turbon 1 again, which is behind tab 10 of volume 1 of the authorities bundle. And we go to one paragraph in Advocate General Misko's opinion, which is at paragraph 47. So the MS number is MS 703. And what he says at 47, first of all, it should be noted that the Commission and the Oberfinance Direction, apologise for my pronunciation, are plainly right in refusing to classify the contested cartridges as accessories to a printer. It is clear that where an ink cartridge is inserted into a printer, the printer is not being adapted for a particular operation to increase its range of operations or to enable it to perform a particular service relative to the main function of the machine, as set out in the explanatory note. It is only being allowed to perform the function for which it is specifically designed, that is to print on paper the data sent in the form of signals by a computer. So the Advocate General doesn't say, oh, well, actually, scenario 1 in heading 8473 doesn't apply for this reason, and then the second scenario doesn't apply for another reason, the third scenario doesn't apply for a further reason. He says that none of those scenarios apply where the machine is only being allowed to perform the function for which it is specifically designed. And the Court of...
Making the same distinction as I sought to make this morning, isn't he? Between the function of the machine and the material upon which the machine is designed to operate.
Well, my Lord, I had understood you were making that observation more in relation to part rather than accessory.
No, I was making it in relation to both.
Yes. Well, my Lord, we say certainly in relation to part, the test is settled. We say it's the capable of functioning test, which was applied in Turbon 2, and no more than that was said in Turbon 2 about what something needed to do to meet the definition of part. Now, the approach that is taken to accessory is not to say, as we see here, and we see from the court's judgment in both Turbon 1 and Medical, is not to say, well, each particular scenario doesn't apply for a reason, but if all the so-called accessory is doing is enabling the main item to do something for which it was designed to do, it's not an accessory. And we see that again if we go to paragraph 32 of the court's judgment in Turbon 1. So paragraph 32, equally, such a cartridge cannot be classified under heading 8473 as an accessory. And then he sets out the three scenarios in 8473. He says they don't apply because such cartridges, sorry, the court says they don't apply because such cartridges merely enable ESC printers to fulfill their usual function, namely the transcription onto paper of work produced with the aid of a computer. And again, we see that approach in Medical. So if we go to Authorities Volume 2, and we have a look at Medical behind tab 15, paragraph 38 of the court's judgment, paragraph 38, likewise, he's referring to the court's referring to the bags. Likewise, those bags do not enable the instruments and apparatus to be, and then it sets out the various scenarios. The court states a drainage bag attached to a catheter has a sole purpose of collecting liquid drained, etc. And then the court states, for its part, a drainage bag for a dialyser does not enable that apparatus to perform operations other than that for which it is designed, namely that of cleansing blood. So in response to my Lord Hodges' question, I don't have a specific submission on whether the bra performs a particular service relative to the main function of the machine, but I say given that the bra does not enable the breast form to perform any operation other than that for which it was designed, it can't be treated as performing a particular service relative to the main function of the machine. And it can't be treated as falling within under any of the two other scenarios in heading 8473.
Thank you very much
Yes,
for clarifying your position. Thank you.
Yes. So I was now going to move on to the orthopaedic appliance and other appliances issue, unless I can assist you further on the part or accessory issue. Okay.
Yeah, it's the accessory which performs a particular service relative to the main function of the machine, isn't it?
Yes.
Right. So Misko, the Advocate General, got this wrong in paragraph 47 because he treated it there. He treated the subject. The way he put it was that the printer is not being adapted for a particular operation to increase its range of operations or to enable it to perform a particular service relative to the main function of the machine.
Yeah, he did. That should have been a reference to the cartridge.
Yeah.
But I think we can understand the point he was making. And the court, in its decision, in its judgment, didn't make the same error, because the court did refer to the cartridges at paragraph 32.
Yes.
Can we move on?
Yes. Okay. Thank you, lady. So now the next issue is the orthopaedic appliance, the final issue, the orthopaedic appliance and other appliances issue. issues, may I just ask you to turn up heading 9021 again? It's in the Authorities Bundle, Volume 1, Tab 5. Tab 5, my lord. It is in other places as well, but it's kind of separately produced in tabs 5 and tab 6, so it's probably easier to look at it in tab 5. So, in heading 9021, the semicolons are important, as Lady Hell indicated earlier on, that we have orthopaedic appliances, including crutches, surgical belts, and trusses. Now, that is one subheading, and we can see the subheading below. So just under 902110 orthopaedic or fracture appliances, we have 90211010 orthopaedic appliances. And the upper tribunal found that the bra was an orthopaedic appliance under subheading 90211010. And then we have, after that semicolon, splints and other fracture appliances, and we can see them in subheading 90211090. Then we have artificial parts of the body. So first of all, we have a title there, artificial teeth and dental fittings. 902121 refers to artificial teeth, and then 90212900 applies to other, so that would be other artificial teeth and dental fittings. And then we have a heading, a kind of a small heading, other artificial parts of the body, 90213100 artificial joints. And if we just turn over to the next tab, tab 6, 902139 other. So this would be other artificial parts of the body not already mentioned. So that's what 902139 is referring to.
What are ocular prostheses? Are those glasses?
Artificial eyes. Lady.
Artificial
Yes.
eyes,
Yes.
not glasses.
Yes. That's another artificial part of the body. And then we have the kind of catch-all category for artificial parts of the body, which is 90213990 other. So that is all other artificial parts of the body not previously mentioned. And the breast form would fall under this particular subheading, 90213990. So if we then go back and look at the heading itself, 9021, we can see that after artificial parts of the body, we have another semicolon, and then we have a final category, hearing aids and other appliances which are worn or carried or implanted in the body to compensate for a defect or disability. And when we now go to tab 6 and we look at the subheadings, just below 90213990, we have 90214000 hearing aids, excluding parts and accessories. Below that, we have pacemakers for stimulating heart muscles, which have another subheading. And then you have other, and other, the only example of other given, parts and accessories of hearing aids. And then you have this subheading, 90219090 other. So that would be anything else worn or carried or implanted in the body to compensate for a defect or disability. So it is this subheading that my learned friend says applies to the bra. And he also still appears to be maintaining that alternatively the orthopaedic appliances subheading applies, 90211010. Now, if we just briefly focus on that subheading, orthopaedic appliances, general interpretative rule 1, which is in the bundle, it's in fact separately set out. It's behind tab 3, it's MS page 663. So, Rule 1, the titles of sections, chapters and subchapters are provided for ease of reference only. For legal purposes, classification shall be determined according to the terms of the headings and any relative section or chapter notes, and provided such headings or notes do not otherwise require, according to the following provisions. Now, the relevant section, as my learned friend indicated, is section 18, but there are no relevant section notes. We do, however, have relevant chapter notes, and that is those are the notes that my learned friend took you to earlier. They're the notes to chapter 90, and they're behind tab 8 of the Authorities Manual, Volume 1. And we can see that in chapter 90, just over the page, so MS page 672, we have note 6. So this is a crucial note to consider when deciding whether the bra is an orthopaedic appliance. For the purposes of heading 9021, the expression orthopaedic appliances means, bearing in mind this is binding, appliances for preventing or correcting bodily deformities or supporting or holding parts of the body following an illness, operation or injury. And the upper tribunal found that the bra fell within that second indent. Now, I don't know the extent to which I need to even make a submission as to whether the first indent applies, namely, is a bra an appliance for preventing or correcting a bodily deformity? Because my learned friend's submissions focus on the second indent. But just in case he relies on it, my brief submission is that the bra is not an appliance for preventing or correcting a bodily deformity. The FTT, paragraph 23 of its decision, found that the primary purpose of the bra was to hold a breast form or breast forms in place.
Why is that inconsistent with preventing or correcting bodily deformity?
Well, what the tribunal went on to say, my lord, paragraph 32, is that the bra cannot alone perform any corrective function, that it can only perform a corrective function when being used in conjunction with the breast form. So the correction of any bodily deformity is not something that the bra itself is for. It's something that is performed by the breast form held in place by the bra.
Why not regard them both then as appliances?
I'm sorry, my lord?
Why not treat them both then as appliances for preventing or correcting bodily deformities?
Well, my lord, in my submission, then we go back to look at really whether the bra should be treated as a part of the breast form, so they're treated as one whole. If they're not going to be treated as one whole, but they're treated as separate items, I say each item must separately satisfy the definition of orthopaedic appliance, because they're not to be regarded as a whole if you decide that one is not a part of the other. So I say it has to be, each appliance has to be considered in its own right.
I mean, this is looking at the purpose of the appliance.
Well, yes. It says for the purposes of heading 9021.
Yeah, appliances for
For.
preventing or correcting. So,
Yeah.
it's what's the purpose of this object? And
Right. Well, no, my lord, in my submission, one has to ask, does a mastectomy bra correct a bodily deformity in its own right?
Well, in one sense, I mean, first of all, that begs the question whether in its own right is the test. But secondly, so far as a mastectomy bra is intended to address the aesthetic and psychological impact of a mastectomy, that would in itself come within the first bullet point, wouldn't it?
Well, my lord, I'll come on to the psychological impact a bit later on, but I say that can only be relevant if it is inherent in the product, in the sense that its inherent character must be capable of being assessed on the basis of the product's objective characteristics and properties. In my submission, lessening psychological impact doesn't fall within that, but I'll develop that submission a bit later. As for saying my submission begs the question of whether it has to be in its own right, I say, well, if it's not treated, if the bra is not treated as a part of the breast form, then it must follow, if it's not one whole, it must be that each individual item that is said to be an orthopaedic appliance must meet the test for being an orthopaedic appliance. So I say it doesn't meet that. On the basis of the findings we have, from the findings of fact that we have from the first tier tribunal, it doesn't do that on its own. So the first year tribunal looked at, they had the bra in front of them. They had, they also actually had all of the items considered in Lohman in front of them. There was a model who turned up to the first year tribunal to wear the mastectomy bra. So they were able to see how it worked. They were able to feel the bra itself, get an idea of how it compared to a normal brassiere. And their finding was that the bra alone did not correct a bodily deformity. So we rely on that finding, and we say that Malone Friend can't get the bra within that first indent. And in fact, he doesn't particularly push a case as to the bra falling within the first indent. He focuses on the second indent, supporting or holding parts of the body following an illness, operation, or injury. And his argument is, my submission first of all, is that the bra does not support or hold part of the body, but it supports and holds the breast form. And what my learned friend says is that supporting or holding parts of the body is able to encompass supporting or holding artificial parts of the body. So it is capable of encompassing something which supports a breast form. What I say about that is that if the expression orthopedic appliance was intended to mean an appliance for supporting or holding an artificial part of the body, such as a breast form, then the chapter note would have said so, and it doesn't. The drafters of the combined nomenclature and the chapter notes were perfectly able to distinguish artificial body parts from the body. What my learned friend says in his written case at paragraph 55 is he says, well, actually, he gets some assistance from heading 9021 because that expressly refers to artificial body parts. But in my submission, that doesn't help him because, as we've seen from the structure of heading 9021, it expressly distinguishes artificial parts of the body. I think that's how it's expressed, from orthopedic appliances. So we say that doesn't help him. So then what he does is that he relies on observations made by Advocate General Cockott in Uroplasty to claim that the word orthopedic has a wide meaning. So it may be worthwhile just going to Uroplasty now behind tab 13 of volume 1 of the authorities bundle. So this is MS page 801. And just briefly, the case of Uroplasty concerned the classification of silicon flakes, which were dissolved in a hydrogel and then inserted into the muscular tissue of the neck of the bladder or the mouth of the urethra to treat problems caused by certain forms of incontinence. And the issue was whether the flakes were a plastic, an artificial body part, a medicament, or an other appliance implanted in the body to compensate for a defect or disability. And both the Advocate General and the court plumped for the last of those options, other appliance implanted in the body to compensate for a defect or disability. Now, may I just take you to the Advocate General's opinion at the MS page number is 809. Just something to bear in mind when looking at the headings in this case. So the relevant subheadings are set out here, and 902130 refers to other artificial parts of the body. Now, the organisation and numbering of that has now changed, and you'll see that from tab 5. Other artificial parts of the body is a heading, and then the numbers are different below as well. So where you have 90213090 other, which is the catch-all category for other artificial parts of the body, that's now 90213990. I think it's just worth pointing that out because otherwise, reading this, one may wonder where the subheadings come from. But they were different at the time the Advocate General gave her opinion. And then if you look at the bottom of MS 809, 9021, 9090, other, that is the subheading that applies to the other appliances worn or carried or implanted in the body to compensate for a defect or disability. Now, the relevant paragraphs that my learned friend relies upon are paragraphs 58 to 61. So if we have a brief look at them, so this is MS page 817. And what the Advocate General says at paragraph 58 is, by contrast, the wording of heading 9021 offers at least a possibility that it covers macroplastic flakes. Specifically, they may be classified as other appliances which are implanted in the body to compensate for a defect. It is unnecessary to decide whether they could also be classified as other orthopaedic appliances. Now, that's the subheading that I think I discussed with Lord Reid earlier, that it doesn't exist in in heading 9021 now, but it did at this time. Then paragraph 59, although one would normally regard the term appliance as referring to some sort of technical apparatus, an approach based on the wording of the harmonised system requires a broad interpretation. The English word appliance means not only apparatus, instrument or device, but also medical support or support. That the English word appliance is in fact intended to include the German Hilfsmittel is demonstrated, for example, by the first item specifically mentioned, indicating that crutches are orthopaedic appliances, which in Germany are regarded as medical supports. Hilfsmittel. Paragraph 60, the French version uses the phrase article et appareil almost throughout as the equivalent of the English appliance, even where the English version uses the phrase artificial parts of the body, whereas appareil could be rendered in German as Apparat or Gerät. Article corresponds best to the German, where I apologise for my pronunciation of French and German, by the way, so I'm probably savaging both those languages, or Gegenstand, object. This too is intended to encompass medical supports and other objects having a medical purpose. This confirms that a broad interpretation is to be given to the German word Vorrichtung, where it appears in the combined nomenclature. And then finally, paragraph 61, thus, read as a whole, heading 9021 assumes a broad interpretation and is intended to cover all medical objects by means of which the medical purposes identified in the heading are pursued. Accordingly, the term appliance does not restrict the technical structure of a product, but is intended to encompass also medical supports, products and objects which are intended to compensate for defects by being implanted into the body. Now, just pausing there, if we see what my learned friend says about those paragraphs, we see that from paragraph 50 of his written case, and that's MS 80. And what my learned friend says at paragraph 50 is that it is submitted that the Court of Appeal erred in holding that the opinion of Advocate General Cockott in Europlasty was not of crucial importance, and in particular insofar as it required a wide meaning to be given to the term orthopaedic appliance. Now, what my learned friend says there is wrong. The Advocate General did not state that any wide meaning had to be given to the term orthopaedic appliance. She was considering the final subheading in heading 9021 of other appliances which are implanted in the body to compensate for a defect. And in any event, she indicated that the term other appliance, when one looks at other appliances, required a broad interpretation only in the sense that appliance was not limited to some sort of technical apparatus, but included supports, products and objects which were intended to compensate for defects by being implanted into the body. And the court agreed with her at paragraph 52 of its judgment. So
they refer specifically to her paragraph 61, which it might be said is a rather wider effect than purely focusing on the word appliance. And And it just says it's intended, 99021 is intended to cover all medical objects by means of which medical purposes identified are pursued.
Yes, but my lord, I say when that's taken in context, it's clear that she has in mind what the term appliance means, because the discussion has been about what appliance means up to that point. And really, the only point she's making is that one can't limit appliance so that it doesn't include supports and those types of objects. So I say no, one cannot take out any broader interpretation than that. She does say some things which are relevant to whether something is an orthopaedic appliance, even though she's not considering that. If you go to paragraph 66 of her opinion, she refers to the potential to classify the flakes as artificial parts of the body, and she says the essence of an artificial body part is that it is a substitute performing the function of a defective part of the human body, generally of a part providing movement or support. This is made particularly clear by the English version of the harmonised system, which uses the term artificial parts of the body for the German prothese. And then she says it follows that an orthopaedic appliance must equally be intended to substitute for at least part of some bodily function. And in my submission, if an appliance is not acting on a real part of the body, but only an artificial part, that appliance cannot be substituting for a bodily function. And then paragraph 67, what she says is that, however, the information provided by the National Court does not indicate that the flakes have any such function of substitution. According to it, the flakes do not themselves perform the function of the defective muscles, but instead promote the growth of connective tissue. Now that could be indirectly relevant in our case, because before the first tier tribunal, it was contended by the appellant that the bra assumed the functions of any muscles that had been removed in the operation, and you see that at paragraph 23 of the first tier tribunal's decision. But what the first tier tribunal found at paragraph 32 was that any corrective functions could not be performed by the bra on its own, but only with the combination of the breast form and the bra. Then, if we go back to the opinion and we have a look at paragraph 69, the Advocate General says classification under subheading 902119 as an other orthopaedic appliance might also be thought appropriate. However, the use of macroplastine flakes is more closely connected to urology, which is concerned with urinary organs, than to orthopaedics. And then she gives an indication of what she regards orthopaedics to be concerned with, because she says, which is concerned with defects in body parts which support movement such as bones, joints, muscles and tendons. And then finally, if one looks at paragraph 70 of her opinion, there is one kind of slightly confusing thing about this paragraph. Paragraph 70, she says, on the basis of the available information, classification under subheading 902190 as an other appliance implanted in the body to compensate for a defect is to be recommended to the National Court. And then she says, the only other possible subheading is subheading 90219090. Now, I don't understand what she means by the only other possible subheading, because that is not the only other possible subheading. On her reasoning, that is the subheading. 90219090 is the subheading for an other appliance implanted in the body to compensate for a defect. So that's one slightly confusing thing about paragraph 70, but doesn't undermine her conclusions in any way. So what I say is that on the orthopaedic appliance issue, on the other appliances issue, there's nothing in this case which helps my learned friend on other appliances, but also on the orthopaedic appliances issue, there is nothing in the Advocate General's opinion that would justify treating the bra as an orthopaedic appliance under one of the two indents in Note 6 to Chapter 90. So we say this decision doesn't really, or the opinion doesn't really get him anywhere. Now, on the second indent, i.e. does the bra support or hold a part of the body following an illness, operation or injury, it is worth just having a look at the persuasive, albeit not binding, harmonised system explanatory note, which is at MS 344. So we have to go, this is in the core volume rather than the authorities bundle. So we have to go to the core volume and it's set out at 344. It's also useful to look at this when considering the other appliances categories. I think my learned friend indicated in response to a question that there was really no other guidance on other appliances, but there is. We have guidance in the form of a harmonised system explanatory note. But if we just focus on orthopaedic appliances for the time being, MS 344 we have there's a reference there to orthopaedic appliances. It states orthopaedic appliances are defined in Note 6. It says what their appliance is for. We have the two indents set out. And then the examples of orthopaedic appliances are listed. So we have 11 examples. They include appliances for hip diseases, humerus splints, appliances for the jaw, traction, etc., appliances for the fingers, appliances for treating Pott's disease, orthopaedic footwear, special insoles designed to correct orthopaedic conditions, dental appliances for correcting deformities of the teeth, orthopaedic foot appliances, trusses, appliances for correcting scoliosis and curvature of the spine, orthopaedic suspenders, and then at the bottom, it also includes orthopaedic appliances for animals, for example, hernia trusses or straps, leg or foot fixation apparatus, special straps and tubes, etc. I can't place too much weight on this. But these are just examples of orthopaedic appliances in a persuasive, albeit not binding note. But all the examples given are of appliances that support or hold natural parts of the body. So one can't take there's no suggestion even in the explanatory note that an orthopaedic appliance is something that supports or holds an artificial part of the body. So this is relevant to that extent. My learned friend also relied on the Court of Justice's judgment in Lohman. Just before we go to that, it is worthwhile just considering the other appliances subheading in a bit more detail. May I ask you to go to tab 2 of the Authorities Bundle, Volume 1. Now, behind tab 2 of the Authorities Bundle, we have some relevant combined nomenclature explanatory notes. And may I ask you to have a look at MS 658? Now, again, this is not legally binding. This is an explanatory note. It's persuasive. And at 658, heading 9021 is set out, and we can see we have the words compensate for a defect or disability at the end there, and that applies to the other appliances subheading. And then the explanatory note says this: for the purposes of this heading, the expression to compensate for a defect or disability means only appliances which actually take over or substitute for the function of the defective or disabled part of the body. This heading does not include appliances which simply alleviate the effects of the defect or disability. We have some examples given of the of other appliances which compensate for a defect or disability, just over the page at MS 659, we see the subheading 9021 1990 other. This subheading includes the following appliances which compensate for a defect or disability. And what we see is that the examples given are all of items which are inserted into the body in some way. So they're implanted, or they're surgically attached, or they're, implanted, surgically attached, or inserted. So they go into the body. But I'm not suggesting this is determinative of the other appliances subheading, of anything that can go into the other appliances subheading, but it just illustrates the kinds of appliances that the drafters of this explanatory note had in mind. I can't really put it any higher than that. Now, there's a relevant harmonised system explanatory note as well, and that is the note that you may well still have open, which is in the core volume, MS 344. And if you could look at MS 347, now we have the subheading, other appliances which are worn or carried or implanted, or the category, other appliances which are worn or carried or implanted in the body to compensate for a defect or disability. And then again, the examples are set out. So it says this group includes speech aids for persons having lost the use of their vocal cords, pacemakers for stimulating defective heart muscles, electronic aids for the blind, and appliances implanted in the body used to support or replace the chemical function of certain organs. So all the examples given are of appliances which compensate for a physical disability of some sort, i.e. an impairment of a physical function. So that is potentially relevant to consider. So what is Malone and Friends' case on why the bra falls within the other appliance category? Well, what he says at paragraph 54 of his written case is that the Court of Appeal should have held that the bra compensated for a defect or disability because he says the bra's very specific purpose was to compensate for a defect caused by breast amputation. Now, in my submission, that is not right, and I go back to my reliance on the findings made by the first-tier tribunal. So the first-tier tribunal found that the purpose of the bra alone was not to compensate for a defect because only the combination of the breast form and the bra did that. That's paragraph 32. And the primary purpose of the bra was found to be to hold the breast form in place. That's paragraph 23. So we say that is not borne, his submission there is not supported by the findings made by the first-tier tribunal. So he has another aspect of his case, and that is what Lord Sumption referred to earlier, the psychological impact. So what he says in his written case at paragraph 58 is that the tribunal accepted, which is right, well, what he says is they accepted at paragraph 25 that a purpose of the bra was to lessen the psychological impact of having had a mastectomy. Now, what he says there is not quite right, because when one looks at paragraph 25 of the first-tier tribunal's decision, what the first-tier tribunal in fact say is that the bra itself does not achieve this, and it is only the bra when it contains a breast form that has this effect. So what he says is not quite right, but in any event, what the first-tier tribunal said at paragraph 25 was that the effect of lessening the psychological impact of a mastectomy was not obvious from examination of the bra. And that is important because if lessening that impact is claimed to be one of the bra's intended uses, what the court stated in Neuroplasty, just for your note, it was paragraph 42, was that intended use may constitute an objective criterion in relation to tariff classification if it is inherent in the product, and such inherent character must be capable of being assessed on the basis of the product's objective characteristics and properties. And the effect of lessening the psychological impact of a mastectomy is not capable of being assessed on the basis of the bra's objective characteristics and properties. The first tier tribunal, having considered...
I could understand how that would be so simply by looking at it,
Yes.
which is what the tribunal said. Right. But considering its objective characteristics and the fact that it is specially designed in order to carry the breast form which substitutes for that part of the breast or that breast that has, or breasts which have been removed, it is not difficult at all to conclude that from its objective characteristics, it will have an impact on the psychological well-being of the wearer.
Well, my lady, I think that depends on how broadly one defines objective
You
characteristics.
bet it does, yes.
Yes, because...
I'm merely putting the point to you that it could possibly be defined rather more broadly than simply by looking at it.
Yes, but, my lady, the appearance is significant. That is important. And what the tribunal found at paragraph 27 was that when one looks at the bra, and obviously the tribunal examined it to some extent as well, what the tribunal said was that it is so close to that of a normal brassiere that it could not be determined from its objective characteristics, that it is worn to compensate for a defect or disability. Now, lady, even if it is possible to broaden the concept of objective characteristics to include something like this, and I say it isn't, that would be too broad, but if I'm wrong, lessening the psychological impact of a mastectomy would at the most amount to simply alleviating the effects of a physical defect. And the combined nomenclature explanatory note tells us that that cannot bring an appliance within the other appliances category. And just for your note, that's MS 658.
Well, isn't it the fact that you substitute for what is no longer there the thing that promotes the psychological well-being? Is that?
Well,
so it's a purpose rather than...
Yes, although the tribunal found that it was the breast form and the bra together that did that rather than the...
Well, yes, of course.
Yes,
that's a different part of the argument.
Yes, rather than... Yes. But on this part, milady, we say that the combined nomenclature explanatory note is clear, that it has to actually take over the function of the... But I may just remind myself what it says. So, yes, what it says is, it's page 658, the expression to compensate for a defect or disability means only appliances which actually take over or substitute for the function of the defective or disabled part of the body. And it's very hard to see how lessening psychological impact of a mastectomy fits within that wording. And then it says the heading does not include appliances which simply alleviate the effects of the defect or disability. Now, one could say that the bra and the breast form together alleviate the psychological effect of the disability, but what the heading tells us is that's not enough. And I would say it's not enough anyway, because it has to be the bra on its own that does that, not the bra in conjunction with the breast form. So then finally, on Lohman, that was the other case that my learned friend relied upon. May I just ask you to turn up Lohman? It's tab 11 of volume 1 of the authorities bundle. Now, Lohman was a case which concerned very different products. So all of the products in Lohman clearly supported natural parts of the body. So they were a wrist orthosis, a lumbar support belt, an elbow band, and functional knee supports. And the argument in Lohman was not about other appliances. Lohman and the other company involved in the case argued that the products were orthopedic appliances. My learned friend relies in particular on paragraph 39 of the court's judgment in Lohman, so we may just want to turn that up. That is MS 759. And what paragraph 39 states is that the criteria for distinguishing simple or ordinary products from those serving a medical purpose therefore include the method of manufacture of the product concerned, the nature of the materials of which it is made, its adjustability to the handicaps which it is intended to correct, or other special characteristics, in particular the specificity of its purpose. Now, if we look at my learned friend's written case, just see what he says about this, it's paragraph 54 of his written case, and the MS number is 81. And at MS 81, what my learned friend does at paragraph 54 is he refers to Lohman, and then he says that paragraph 54, the Court of Appeal erred in holding that the intended purpose of the mastectomy bra was not to compensate for a defect or disability. Its very specific purpose is to compensate for a defect caused by breast amputation. Now, what my learned friend is doing there is conflating the different subheadings under heading 9021. If an appliance is worn or carried to compensate for a defect or disability, it's not an orthopaedic appliance, but it falls into the other appliances subheading. I've already made submissions on why I say it doesn't fall within that subheading. So he's using Lohman in a kind of slightly wrong, well, in a wrong way, really. And one has to, one can't look at paragraph 39 anyway in isolation. One has to look at paragraph 40 of Lohman, MS 760, where a product exists in different versions and where in its simple or ordinary version it serves a general purpose, whilst in a different version designed to perform a medical function it is used for orthopaedic purposes. It is only in the latter version and by application of the above mentioned criteria that it is to be classified in heading 9021. So it still has to be used for orthopaedic purposes, and to be an orthopaedic appliance, it must still fall within one of the two indents in note 6 to chapter 90. So it's not enough for it to have a vague medical purpose. It must fall within one of those two indents. And then paragraph 43, finally, the court stated, it follows that the products at issue in the main proceedings fall within heading 9021 if they display characteristics which distinguish them, in particular by the materials of which they are made, their method of operation, or their adjustability to the patient's specific handicaps from ordinary belts and supports for general use. Now, applying that paragraph to the present case, the first-tier tribunal found that there was little to distinguish the mastectomy bra from a normal bra. It stated at paragraph 19 of its decision that save for the positioning of the pockets, the higher cups to cover the breast form, and the central positioning of the straps, there was not one feature of the bra that would not be found in an ordinary bra. And the tribunal also found at paragraph 27 that the appearance of the mastectomy bra was very close to that of a normal bra. So I say that the guidance in Lohman does not advance the appellant's case.
While you're on Lohman, could you look at paragraph 26? This is a rather more different point that Mr. Aiken makes. Really, this is emphasising that the Court of Justice's function is not to decide individual cases on the fact, but to give guidance.
Yes.
And it could be said that in some of the later cases they've gone rather further than that.
Yes.
Would you agree? I mean, I note you're not asking us to make a reference in this case.
Yes.
You're accepting this is something the national court's got to sort out for
Yes.
themselves.
Well, my lord, I think what they do is that they set out what the guidance is. So, for example, they'll say what parts are or what accessories are, what those concepts mean, and then based on the facts before them, it's inevitable that the particular product can't meet the concept. So they perhaps do go. They sometimes do go that step further and say. It doesn't fall within the concept. All they say, as we've seen in one of the other cases, it's recommended that this particular heading should apply. But we say really that is just
And you accept that the proper approach they should be adopting is that set out in paragraph 26.
Yes. Sorry, just one moment. Unless I can help you, I think I'm actually out of time anyway, but unless I can help you further, those are my submissions on orthopaedic appliance and other appliances.
Thank you very much indeed, Mr. Singh. Thank you.
Thank you.
My lady, my lords, just briefly in reply, just as we were last looking at loan, your lordships will have our submission that as a matter of principle, of course, even though in that case they were looking at appliances, there's no reason why the same approach should not also to appliances worn to compensate for a defect or disability under the 1921 heading. And the specificity of purpose and the medical purpose that is the emphasis is emphasised here is of course reflected in the Advocate General's opinion in Europlasty, in particular paragraph 58 through to 61, which we looked at earlier. Can I then just make a few general submissions, in particular in light of the debate this morning between the court and my learned friend about accessory and part, and then attempt to answer the question my Lord Carnworth put to me, which also I think is the strongest. But again, perhaps just to take back the analysis, and a lot of the debate in my learned friend's case was one premised on the basis that there are multiple forms of breast forms, some which require a mastectomy, or some which don't require a mastectomy bra, and others which do. But of course, we are here concerned with the question of the classification of the mastectomy bra, and not of the breast form. The breast form is a given as an artificial body part, and therefore the question really has to be not are there other breast forms, but is this mastectomy bra, when used, either a part or an accessory, a part to something greater, namely together with the breast form, a part of the prosthesis, or an accessory to that. And of course we have, and I took you to that at the outset of my submissions, in Oliver Medical, at tab 22, volume 2 of the authorities, page 1062, again, the premise and the whole starting point for the analysis is the interest of legal certainty and ease of verification. And of course the suggestion that every time a patent runs out and somebody else comes up with another breast form or another mastectomy bra, therefore it would have to be reclassified, neither supports legal certainty nor ease of verification, in my respectful submission, and seems to be hardly a mechanism by which the CN could operate. But we see then, again, at page 1063, that of course the focus is on the intended use of a product, which is what has to be analysed. And in order to establish, paragraph 51, whether a product is intended for medical use, it's appropriate to take account of all the relevant factors in the case as set out in the order for reference. And that includes, for example, and we had this earlier, classification on the Medical Devices Directive, but also, we say, all the factors my Lady Hale put to my learned friend about the psychological impact and the intended use, which is clear from the material that was submitted. So if one approaches it from that angle and looks at the mastectomy bra rather than at the breast form as a starting point of the analysis, one then looks at the definition in Turban 1 at page MS 724, of a part, namely, it implies a whole for the operation of which the part is essential. And of course, we have here a mastectomy bra which, on the evidence, will inevitably be, or almost invariably be, worn together with a breast form, the whole of which forms the prosthesis, and for the operation of which, as the courts below held, it is essential, and therefore we submit there is a strong case on the language and on the facts found for it being a part. If one then looks at the accessory test, there is that difficult phrase in the accessory test at paragraph 32, namely to perform a particular service relative to their main function or to increase their range of operations. And while on the ordinary language, in my respectful submission, it is difficult to see why a mastectomy bra would not perform a particular service relative to the main function of the breast form, and therefore also be capable of being classified as an accessory. We have these statements in Advocate General Maduro's and in some of the judgments, where it seems to be taken as an obvious that the breast form to perform a particular service relative to their main function is an add-on service rather than something that facilitates it achieving its purpose. Where, of course, as my Lady Hale put to me, it may well be said that actually the mastectomy bra in this case does operate to increase the range of operations because it enables it to have the psychological effect and in the psychological effect intended by the operation. And therefore, looking at both those definitions, I can well see why the Court of Appeal, Lord Justice McComb, and as a matter of fact, the Australian judge felt that it was most obviously classified as an accessory, because that seems to fit with the common language and the added value it adds to the breast form. But there is that niggling uncertainty as to what those words in fact mean, because the Advocate Generals take it to mean something which, in my respectful submission, isn't necessarily obvious, certainly from the English language version of the text, and we haven't got any of the others. And therefore, if I had to put my money on one of the horses, I'd just by a nose, I think, in my submission, the parts case is the one, I think, on the language in paragraph 30 of the Turban International number 1 case, is the one we would advance with in the alternative, arguing that it is an accessory, and yet again in the alternative, that it itself is an appliance which is worn to compensate for a disability or defect.
Could you just help me on one point on the FTT's decision?
My Lord, yes.
If one goes to page 134, we see your case as it was before the first tier, which included the idea that line 34, that the bra acts as an accessory to another article classified, namely the breast form, which is your part of your case today. Did they actually deal with that in the FTT? I couldn't see where they dealt with that point.
No, my Lord, they didn't. As the Court of Appeal noted, the first-tier tribunal did not adjudicate on the question of accessory or part. That was first determined in paragraph 57 of the...
Yes, but I know the upper tribunal did, and of course, if they were right on that, then clearly the first-tier tribunal made an error of law, and so they were entitled to make their own decision on the facts.
My Lord, yes. And of course, we know in paragraph 69 of the upper tribunal, page 155, they do find that the Carmen mastectomy bra is an orthopaedic appliance.
So they deal with the other point, yes.
Because it performs a function.
The accessory point, the part or accessory point, they don't actually deal with.
The FTT didn't deal with, and that is dealt with by the upper tribunal at paragraph 57, where we say it deals both with the definition of accessory and the definition of part, both of which are, we say, the correct tests. Those, I think, if you just bear with me, those, I think, are all the submissions I have in reply, my lady, my lords, unless there is any further matter I can assist the court with.
I don't suppose you've got a sample, have you?
We
The real
don't
thing.
have a sample here, my lady, no.
I understand we're not judges of fact, any more than Luxembourg is a judge of fact, but nevertheless, we have to take our descriptions from the pictures that we can see on the
My lady,
screen.
there is a little detail. If the court wishes it, of course, we can provide a sample if that were helpful.
Are we going to be given the Australian judgments?
Well, that would be helpful too.
The Australian decision we have here, we can make available to the court immediately, as I indicated at the outset. In relation to a sample, that may take a day or two, but we can certainly do that if that were helpful.
Well, unless Mr. Singh has any specific objection.
Not to the sample, lady. On the Australian decision, I've made no submissions on it at all. But I mean, if you are going to read it, the only thing I would say is that it's a first-tier Australian decision. The tribunal obviously wasn't bound by the Court of Justice authorities on part or accessory, and it didn't, in fact, specifically consider any of them. And we don't know whether the decision is going to be appealed or not. So I don't have any objection to you looking at it, but I would just say you should place no weight on it at all. It has no value.
Well, we do understand why
Yes.
you would say that.
Yes.
Well, my lady,
We
I
have
think
no
that's the
objection to
basis
it.
on which I introduced it. It was to complete the picture.
Yes.
I'm not making any submissions asking this court to place...
Well, obviously, the USA, if there's a
They
state
seem
or
to take
states
into
in the
account
USA
all
that
your
have reached
decisions
a
in this case.
Well, my lady,
particular conclusion, they're not bound by the Luxembourg decisions either.
and there are no, we are not aware of any other court decisions. So the only reason I drew it to the court's attention is because that is the only other court, save for the three courts below here, who have considered this issue and they've reached a particular view, which on the part issue actually goes against me. So I'm
They seem to refer to the Court of Appeal decision. This,
they certainly analysed the Court of Appeal decision and then decided that because the Court of Appeal felt bound by the European decisions, which of course don't apply to the Australians, he had to start from scratch and looked at what the Australian court said, what is an accessory, what is a part. But that, of course, is in one sense relevant. While we're bound by the ECJ on the guidance, we are, of course, applying a system that is applied worldwide beyond the EU and not just an EU-specific instrument. So shall I will get my client to provide a sample if that is acceptable.
No objection to that.
Well, if that's not objected to,
I'm grateful.
it would be helpful illustration. Thank you. Well, we're most grateful to you all for the interesting way in which you have presented this conundrum to us, and that is to everybody who's been involved in it, and we shall let you know our resolution of it in due course.
Grateful, my lady.